Good evening, this is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 8. We are continuing some of the work that we did last week dealing with other types of dispute resolution processes. We got as far as talking about expert appraisals, or case appraisals is another word for it, expert determinations, and early neutral evaluations. Now, if you look at page 3 of your text, you'll see that on the continuum they are 9, 10 and 11. So they're very similar. So these ADR processes are essentially more adjudicatory than consensual, and the terms are somewhat used interchangeably. So because this is a relatively new discipline, we do find that there's a lot of crossover. What we can say about those three types of ADR processes is that there are some common features. So we'll just deal with those firstly. Generally speaking, whether it's an appraisal or a determination or an evaluation, we're dealing with some expert, typically an industry expert or perhaps a lawyer. It's relatively informal. There are no rules of natural justice. There's no need for a written decision. And they're the common things between each of them. What is different is the extent to which they might be binding. Expert appraisal is generally not binding, or in the case of a court-ordered case appraisal, it might be conditionally binding if the parties choose not to accept it. Expert determination is something that is binding, and evaluation is binding, but only in relation to the finding of key issues in dispute, because the nature of an evaluation is for the ADR practitioner to seek out certain aspects of the dispute and make suggestions and make some findings in relation to it. So when it comes to the specifics and trying to get your head around how to describe each of them, my suggestion is you go back to NADRAC. Go to the definitions in NADRAC, and that's an easy way for you to say with some degree of confidence, this is the approach that I will take when describing appraisal or determination or evaluation. Now, I need to temper that comment with the reality that not everyone follows NADRAC. So, for example, if you look at Section 46 of the Civil Proceedings Act 2011, it provides that a court may subpoena a person to attend a case appraisal. And in that context, the term is almost the same as early neutral evaluation. So there are those crossovers, as I mentioned. Look at NADRAC, have a look at, say, Section 46. So evaluations, which is the most formal of those options, is usually done by a former senior judicial officer or a senior legal practitioner. And the evaluator provides a statement about the relative strengths and weaknesses of both parties' cases and offers an opinion as to the likely outcome of court proceedings. So in that sense, evaluation is somewhat similar to a conciliation, but it's done remotely. And that's why it's more adjudicatory in nature than, say, conciliation. Now, the opinion which is provided by the evaluator is not strictly binding, but it is highly persuasive. And hearing some statement by a former judge, for example, as to what the likely outcome will be in a case has a great deal of effect. So let's have a look at some case examples in relation to how evaluation might work in practice. To do that, I'm going to share the screen and hopefully take you to the correct screen. Does that come up as a case from Jade? Is that what you're saying? Good, okay. I don't know about the pronunciation. IPO or EPO against TPS property number 2 and another. So here we have a case in relation to a breach of contract. It was negligence, and you'll see that there is reference to expert determination. And the expert determination was contained in a clause. This case was all about the ability to stay proceedings and whether claims should be struck out or stayed on the basis that they had been the subject of binding expert determination. So I mentioned before expert determination not binding, sometimes it can be binding. Now, if we look at this particular case, where I think it's instructive is at paragraph 91, and I'll try to expand that to make it a bit easier to read. You'll see that there's reference now to the clause that the parties entered into in that case, and it provides that the expert determination will be binding, final and binding, and clause 39.6 provided that the determination will be final and binding unless a party gives notice of its intention to initiate proceedings in respect of the determination. And the court basically supported that argument. Now, what that tells me is that this case is useful because it provides some precedents for those of you that wish to practice in commercial law and draft agreements. And if you're called upon to to draft something which may have final and binding effect of sorts, then that's a useful guide. The other thing is that it shows how expert determination is used in practice. Now, that case was in 2004. The citation is 2004 NSWSC 289. But it has been applied recently in a Western Australian decision, and that is the decision of, hopefully this will take us to the top, Mineral Resources against Pilbara Minerals, 2016 WASC 338. That case is instructive for a number of reasons, but I'm going to refer you to paragraphs 103 and 104. So this is essentially the conclusion of the court. I acknowledge the company's desire to have a day in court, but in my view, it bargained away that right in favour of the finality of an expert determination. The company has not met the heavy onus of establishing why a stay should be refused in the circumstances of this case, and I consider the dispute as amenable to determination by the appointed expert. There are undoubtedly arguments to be developed by both parties regarding the proposed sale notice, which was the subject of the agreement, and that can proceed within the expert determination process. So that case, and the one that preceded it that I showed you, gives clear statements from Supreme Courts in New South Wales and Western Australia that where the parties have come to an agreement about the nature of the expert determination, then it will be upheld by the court and it will be determined as binding on them. So there are some differences, but I'll leave you to read the definitions and work on creating a little list for yourself of what you believe are the similarities and the differences between case appraisal, determination, and evaluation. Maybe that would make a good exam question to identify the differences and cite some examples. Maybe. When you're doing that, also think about legislation and think about practice directions that may be applicable. Practice directions are often overlooked, but first I want to refer you to legislation and have a look at the Civil Proceedings Act, section 41, which deals with case appraisal. Case appraisal is a way of providing for a decision that is not binding until the prescribed time for the rules has been passed. And as I mentioned, in that particular section, it is very similar in its definition to neutral evaluation or even expert determination. Also have a look at section 45 and 43 without necessarily going through that in full. Then consider the UCPR, the Uniform Civil Procedure Rules. I take it that most of you have done civil procedure, or is that next year? Has anyone done civil procedure? All right, Oh, Steve has, yep, Paul. Okay, so civil procedure, you'll be well familiar with UCPR. The Uniform Ellen as well. Uniform Civil Procedure Rules 1999. In relation to case appraisal, have a look at rules 334 through to 345 inclusive. It talks about the whole process of case appraisal within the context of uniform civil procedure disputes in Queensland. How the dispute is referred to the case appraiser, what is the jurisdiction, it deals with appearances from parties, the recording of proceedings, the decision costs, what is the effect of the decision, certificates, what rights, if any, does a dissatisfied party have to continue, and how does that have a bearing on costs, and can you provide for a replacement case appraiser. So when it comes to the take-home exam, you'll probably be given a scenario, and that's the way I like to frame my questions. And within that context, it may be that you're to advise a party about the ADR processes that a court is likely to invoke, and to explain to the party how long it might take for the ADR process to work through, how much it might cost, what will be the obligations on the parties, how much preparation is involved in that process, etc. And perhaps contrast that with, if you like, non-court ADR processes, so that you may be offering an alternative, indicating that before a party litigates and deals with this statutory regime, it may wish to consider mediation or conciliation or some other form of ADR. And the client's going to be looking to you for that advice. What you don't want is a situation where, having initiated proceedings, you then find that these ADR processes are being prescribed, and your client, who has said right from the outset, I don't want to talk to this bloke or this woman, there's absolutely no point. That's why I want you to go straight to court. They're going to come back to you and say, I told you to go to court. Now we find ourselves in ADR. I'm being involved in some sort of case appraisal. Why didn't you tell me about that? So you've got to understand the process and be prepared to explain it to the client, and where relevant, provide alternatives. Now, one of the advantages of mediation and conciliation is the aspect of confidentiality. And I would like you to have a look at Section 53 of the Civil Proceedings Act, which deals with the issue of confidentiality in the context of case appraisal. And essentially it says that evidence of anything done or said, or any admission made in an ADR process about a dispute, is admissible at the trial only if the parties agree. So it's similar in context, but it's worded differently to say it's admissible unless or only if the parties agree to it being so. Okay, so now if I can just give you this tip. And the question is, when would you encourage expert appraisal, expert determination, or early neutral evaluation? Well, like all forms of ADR, each of these, appraisal, determination, evaluation, is informal, speedy, effective means of resolving. I shouldn't say all means of ADR, like many processes in ADR. I would say that these methods are useful, particularly where you've got a dispute involving scientific or technical issues, or issues about a dispute of a specialised kind, because a common thread in appraisal, determination and evaluation is the fact that you're engaging some form of expertise to make the decision or provide opinion about the decision. It also provides an opportunity for the parties to determine the process. The parties generally get to choose the expert. They can choose whether they wish to be bound by the decision or not. And even if it's not resolved, the process can identify clear issues for determination and help the parties to identify the facts they agreed upon, the facts they disagree upon. And it has the ability to have a promotion of the ongoing commercial relationship between the parties. So the way I see case appraisal, determination or evaluation is that it is useful in the context of a commercial dispute, generally that's fairly technical and one where an expert in that field is required. It's certainly not just for that. That's just my take on it. You may have a different view, and you might be inventive and see ways in which those sorts of mechanisms can be used in a wider context in different sorts of disputes. Now, if you look at the graph on page 3, you'll see that the second from the bottom, second only to arbitration, is referencing out. Referencing out is undertaken by a court as part of litigation. And what it means is that the court will refer a matter to a referee, and the court can then adopt or reject the referee's report in part or whole. Essentially, it's an admission by the court that it's not an expert in all areas, and it may be very useful for the court to refer out an aspect of the dispute to a referee for a report to be given to it. So, you might ask yourself some questions if you're involved in advising a client about ADR. Why would a court choose to reference out? Do you want to promote that as part of the litigation? And if so, do you want the court to be bound by the decision of the referee? No, it's not, but can you promote that as something that the court might consider? And what is the legislative basis for appointing a referee? So have a look at the UCPR once again. Refer to rules 501 to 506, which deals with the process of ordering a reference and obtaining and dealing with the report and remunerating the referee. In terms of other dispute resolution processes, another is adjudication. You won't find this on the list of 1 to 14, but adjudication is used in building matters particularly. If you refer to the Building and Construction Industry Payments Act 2004, you'll see reference to adjudication. That's typically done through the QBCC and QCAT. And there are issues that are useful when you're dealing with subcontractors. And seeking an adjudication in relation to a building matter is often used by subcontractors under the BCIPA Act, which is the Building Construction Industry Payment Act, as I mentioned before, and adjudicators have certain powers conferred upon them by legislation. You need to know about these alternatives because if that's the most appropriate form of ADR or adjudication, which is kind of borderline ADR, then that's something you need to explain to your client. So adjudication is a more formal process than conciliation, and it's something which allows for the decision maker to make a decision. I'm just going to share a screen and show you from a website how this might be used in practice. So we see there the website for body corporate and community management, which would be relevant in these circumstances. And that's from the Queensland government. So you can make an adjudication application if you've tried self-resolution, and in most cases you've attempted conciliation. That would generally be in the context of body corporate disputes with the Office of the Commissioner for Body Corporate and Community Management, the BCCM office. So that's website is qld.gov.au/law/housing and neighbours /body corporate, and then from there you'll be able to find it. Okay, so adjudicators determine disputes that involve contravention in the context of body corporate of breaches or alleged breaches of the Body Corporate and Community Management Act, and a community management statement for community title schemes. Also, have a look at these issues in the context of building disputes. I mentioned the QBCC, which is the Queensland Building and Construction Commission. And there's a reference there to help getting paid under BSIPA, which is for subcontractors. So the adjudicator's decision in this context is based on information about valid payment claims, payment schedules, and properly made submissions. It's an adjudication. You can see adjudication online application here. So maybe look at that, have a look at the application. It'll give you a good idea as to when it's to use. There's a link here to what is adjudication within the context of BSIPA. And the provisions of the Act are the Building and Construction Industry Payments Act and Part 4A of the Queensland Building and Construction Commission Act, if relevant. So that's the QBC's Act itself. So think about that form of dispute resolution if you're dealing with subcontractors and you're dealing with commercial matters. All right, the other type of dispute resolution process that I'd planned to speak with you about tonight as part of the tail end of week 7 is criminal justice. I'm going to hold that over because I do want to talk about restorative justice in a bit more detail. So now, finally, we're on to week 8 content, which is based on chapter 7 of your text, and it deals with statutory dispute resolution schemes. Steve, I note the time, but whenever you have to go, thank you for attending this evening. That might be a good opportunity for me to ask generally, are there any questions? I'll just have a look at the chat facility. No, nothing on the chat facility. Any questions, comments? Confusing? Exciting? Interesting? ADR is such a big subject that I think if you don't do ADR, I guess I'm pushing my own barrow here a bit, but if you don't do ADR, you're just going to miss out on so many options that are not just considered as alternatives in a vague sense, but they are really built into the system as part of the substance of our law and dispute resolution now. Okay, so let's have a look at statutory dispute resolution schemes. I've already started on this, for example, in looking at the adjudication online process. But before I do, I'm going to digress with 2 issues. The first is, I think next week is feedback week. Please go to the big red button, push on there. When you do, preferably give me some good ratings and some good feedback. I'd really appreciate that. It's important for me and it's important for the university. If there are any issues of concern, let me know. If you're not happy with the assessment regime, then let us know. Do you believe you're gaining what knowledge and skills you need to obtain from this course? If not, let us know. If there are expectations you had which have not been fulfilled, please let me know. I've been fortunate enough to be taking this course, I think, for the last 3 or 4 years now, and obviously I look to improve it as I can. The second thing I wanted to digress about is the presentation of your paper. Those that have worked with me in the past will know that I'm very keen on the manner in which you present your paper. Referencing is critically important. Make sure it looks the part. It will gain my confidence when I come to review your briefing paper from the outset. Have a look at my sample document. I think I've got that on the website. Follow those basic rules. Make sure that you use footnote referencing, all those basic things. If you have any questions, ask, but otherwise follow those guidelines. I won't go into any detail about that right now. Okay, so court-based ADR. ADR operates through statutory force in courts and tribunals. It operates in that manner in federal and state jurisdictions, and it can be compulsory and it can be voluntary. So many ADR processes operate within the court and tribunal system. Some operate externally, for example, in neighbourhood disputes, domestic violence types issues. Then the courts will consider referring to the dispute resolution centres, which provide a wonderful service at very low cost. So if you don't know about your local dispute resolution centre, I'd urge you to do so. Where I am in Hervey Bay, it's the Wide Bay Dispute Resolution Centre, but there are counterparts, I think, throughout Queensland. So they deal with issues that might be useful in terms of family disputes or disputes between neighbours, for example. Okay, so a tip. When you think about the court or tribunal ordered ADR systems, think about whether you would be proactive in pursuing these options and warn your clients about the likelihood of a referral to ADR. Clients don't like it if they are surprised, because in part it means that their expectations have not been fulfilled, and also they then are concerned about your experience or ability for not having warned them about these options. So the idea is to have a good idea, best you can, as to when a court or tribunal is likely to refer the matter to some sort of ADR process. Now, there are some guidelines to this, and at a federal level, there are ADR processes built in to a wide range of courts and tribunals. So, for example, if you have anything which is involved in the Federal Court, the Family Law Court, the Federal Circuit Court, the Administrative Appeals Tribunal, or Fair Work Australia, then odds are you're going to have some sort of involvement with ADR process. Now, all of this goes back to September 2009. At that stage, NADRAC was busy, it was operational. It no longer is in existence as such. But one of the things that NADRAC did was in September 2009 release the report to the Attorney General about embracing ADR to improve access to justice in the federal jurisdiction. I'm going to share the screen and you'll see the front page of that report. I take it that's what you can see. So September 2009, it's a very lengthy report, but there are some things that are directly relevant to the law as it is now, and I'm going to take you to, firstly, page 3 of the executive summary, and there it is. On page 3 of the executive summary, it outlines the premise, and it says here in this first paragraph under Chapter 4, a significant barrier to the use of ADR is the widespread lack of knowledge and understanding of ADR amongst the public, disputants and professionals. Many people don't know or fully understand ADR, and that results in suspicion, confusion, unrealistic expectations, or dissatisfaction. That's exactly what I was saying before, that clients, if you don't tell them about ADR, you don't explain ADR, they will be suspicious, confused, their expectations will not be met, and they'll be dissatisfied. So the premise of this report in trying to embrace ADR into access for justice is to acknowledge some of those barriers. It also then goes on, and I'm just looking at the executive summary, the document itself is very lengthy, but on pages 4 and 5, you'll see the way in which NADRAC describes the better court process using ADR techniques, and it says Chapter 7 deals with the way that courts and tribunals could be further enhanced to make them more time and cost effective. That is a very familiar theme coming through lots of legislation now, where it talks about efficient use of time and cost. And it all comes about as a result of the High Court decision in Aon Risk Services Australia, which involved the Australian National University. Keep that case up your sleeve. Aon Risk Services and ANU. Google it, you'll find lots of material on it because it talks about the way in which the courts must use the resources of the courts effectively. It introduced the concept of case management, which is now widespread, and NADRAC have adopted that and enhanced that as part of the philosophy behind the laws that have changed following this report. So we look at the recommendation on page 7 of the executive summary, and you'll see, number 1, the recommendation from NADRAC that legislation governing federal courts and tribunals requires genuine steps to be taken by prospective parties to resolve the dispute before going to court or tribunal and commencing those proceedings. That's the critical part of this report. And the critical words, genuine steps. While we're on this document, which is extremely lengthy, I'm just going to take you right to the end virtually, down to page 185, if I can get down there quickly enough. I wanted to show you this. Attachment D. How's this for a precedent? There's a model ADR clause, and that clause is very useful because it talks about the dispute resolution procedure in a contract, so that if a dispute arises in relation to this contract, a party is not to commence court proceedings unless they have participated in mediation. It doesn't apply for an application for urgent interlocutory relief, but then goes on to talk about the process of giving written notice, coming to an agreement on a timetable within a short period of time, appointing a mediator, and dealing with issues if a party refuses to attend. And you can see the acknowledgement there at footnote 512 that NADRAC acknowledged the assistance of the Law Society of New South Wales in drafting the clause. Okay, so that's something to keep up your sleeve as well. Okay, so that was the background at a federal level, which created a big change. It was based on ANU and Aon services. NADRAC promoted the idea that before people could go to, say, the federal court, they would have to undertake genuine steps to do so. Have a look at now, here's where you need to make sure that you cover the field to a degree. Remember that when you're looking at court prescribed matters, you need to consider legislation, you need to consider rules and regulations, you need to consider practice directions. Really important. Have a look at the Federal Court Rules of 2011 and look at Rule 8.02. And it requires an applicant to provide a genuine steps statements where the Civil Dispute Resolution Act 2011, Commonwealth of course, because we're dealing with federal, applies to a proceedings. So that rule says an applicant must provide a genuine step statement. It also refers to the Civil Disputes Resolution Act and says that statement applies where the Act applies to a proceeding. A proceeding is instituting something in court, which will be a claim or an application. Now, my computer has just frozen as I'm trying to establish a link to the Act itself. So what I might get you to do is have a look for yourself on your own screen, if you can split the screen, at the Civil Disputes Resolution Act. And I'm going to sit here while I wait for my computer to write itself, and let me have a look at this Act as well. So I want you to have a look at sections 3, 6, 7, 8 and 9. And I'm just going to go about this by going through the Federal Register of Legislation. That'll be quicker than trying to follow this hyperlink that hasn't worked. I don't know about your internet, but mine is dreadful. I'm told that it will improve, but seems to be a way off yet. Okay, so have you all had a chance to dig out the Act? So that's the Civil Dispute Resolution Act of 2011. And the sections that I particularly want to refer you to at this stage, sections 3, 6, which is genuine steps by an applicant, 7, genuine steps by a respondent, 8, which is the genuine steps statement, also referred to in Rule 8.02 of the rules. 9's interesting. Now, have a good look at 9 in the context of you being a lawyer. A lawyer acting for a person who is required to file a genuine step statement must advise the person of the requirement and assist them to comply with the requirement. There is a penalty, you know. If you don't, as a lawyer, do that, then courts will punish the party, the courts will punish you. And the sections 11 and 12 deal with the issue of a court, and I'll just share the screen. You've been looking at me, haven't you, instead of the screen? All right, so there's section 11 and 12. There's 9, the duty of the lawyers to advise people. 11 and 12. So 11 deals with the requirement to have the genuine steps undertaken, and 12, the exercise in discretion of awarding costs, which can apply to the lawyers. I'd like you to think about that section within the context of the explanatory memorandum. So I mentioned a list of things that you should consider when you are undertaking research: the Act, the rules, the regulations, the practice directions, and also, and you'll remember this from statutory interpretation, very importantly, the explanatory memorandum. So here we have the explanatory memorandum for the bill, Civil Dispute Resolution Bill, and in particular, have a look at the detail as to why the bill was introduced and presented. Look, here's a tip. When you are doing your take-home exam, if you have cause to refer to the explanatory memorandum, you will do well. It shows a depth of knowledge and research beyond looking at simply the Act. That comment applies to all of your law subjects. Always consider looking at the explanatory memorandum as it's described in the Commonwealth sphere, or the explanatory note as it's described in the state sphere. You see, in this instance, given that I'm talking about genuine steps, this explanatory memorandum will help you on the take-home exam, because if you need to describe what a genuine step is for a client in relation to a federal dispute, knowing that you have this obligation to explain it, and the client has an obligation to undertake it, the next question is, well, what do you mean by genuine steps? First place, look at the explanatory memorandum. That will explain to you what the Parliament meant by the term explanatory, by the term, genuine steps. So have a look at that legislation and have a look at the examples of what is meant by genuine steps. So the bill gives some examples of why steps might not be taken. There might be some urgency. And you'll see that the bill does not prescribe specific steps to be undertaken. So what that means is that you won't necessarily specifically find a definition for what is a genuine step. there is no particular prescribed or specific step. What the Parliament had anticipated is that the most appropriate steps will depend on the circumstances of the dispute. So the bill is deliberately flexible or intentionally flexible to enable the parties to turn their minds to what they can do to attempt to resolve the dispute. You see that? So that is a wonderful quote. When you're trying to explain to your client what is a genuine step, when you're trying to work it out for yourself, and more particularly if you're in front of a court arguing that your client did take genuine steps, you can refer back to that statement as an indication, clear indication as to what it is that Parliament had intended by that. Now, I mentioned that there are some things that are excluded, and the genuine steps, the exclusions relate to certain matters which relate to, I'm just looking to see if I can point you in the right direction here for the specifics of it. Yeah, so there are some matters referred to in this explanatory memorandum in relation to some specific mandatory pre-action requirements in other jurisdictions, such as the Administrative Appeals Tribunal or Migration Review Tribunal. Okay, so genuine steps. That was recommended. You now see it in the legislation. Refer back to page 31 of the NADRAC report if you want some further detail as to how that came about. So that's the explanatory memorandum. If we look at the Act itself, have a look at section 4, which provides a statement about the genuine steps to resolve a dispute, and a person takes genuine steps to resolve the dispute if they make a sincere, I'll just share the screen again, and committed approach to resolving that dispute. So it then goes on to provide some examples of the steps that a person could take to resolve the dispute in subsection 1, and a statement that in subsection 2 that subsection 1 does not limit the steps. So again, in that legislation, it emphasises the flexibility which was talked about in the memorandum. Now, I mentioned the importance of knowing the regulations because if we look at section 17, it says that there may be excluded proceedings, and the way in which you determine whether a proceeding is excluded or not will be to look at the regulations. So I'm going to call up, if I can, the regulations, which are the regulations made pursuant to section or subsection 17(1) of the Act. So here we have the dispute resolution regulations, and you'll see that for the purposes of section 17, certain proceedings are prescribed. If they're prescribed, it means that they are excluded from the genuine steps obligation, and there are 3 of them. An application for or proceedings for a sequestration order under section 43 of the Bankruptcy Act, if the Act of Bankruptcy is referred to under paragraph 41G, or proceedings under section 459A of the Corporations Act to wind up a company if the applicant relies on the company's failure to comply with a statutory demand, or proceedings for review of a decision of a registrar. I'm just going to stop there for a sec. When you have an application for bankruptcy, you need to, as an applicant, rely upon an act of bankruptcy. And if you're looking to wind up a company and you do so by way of failure to comply with a statutory demand, you're essentially arguing that there are certain things which take it outside the ordinary. Let me explain that a bit more. I mentioned that the bills have explanatory memorandum. Regulations have explanatory statements. So we can see here, if I click on explanatory statement, you'll see how it goes on to then to describe the rationale for excluding these proceedings. Why would you exclude these particular matters from the obligation to have genuine steps? So in bankruptcy, it's not a proceeding between the parties per se. There are elements of public interest involved, and realistically, there's usually a high volume number of cases going through. So there's a bit of public policy in that decision. Now, statutory demands are essentially this: if you serve a statutory demand on a company, what you're basically saying is you've got 21 days to resolve this issue. Otherwise, that is a ground relevant for me to take to a court to have the company wound up. And again, there are public policy issues behind that. So what I guess I'm saying is this. If in the take-home exam, for example, there is a dispute which revolves around a potential proceedings for bankruptcy, you need to be able to explain that this is federal jurisdiction before you have proceedings. The default position is that there must be genuine steps taken to resolve the dispute. But having said that, this is an exception to that, which means that your client can initiate the proceedings for winding up based on failure for the company to comply with the statutory demand under Section 459 Cap A. So if you can do all of that, refer to the explanatory memorandum, refer to the explanatory statement in the case of regulations, then you're doing a really good job. Other federal legislation, have a look at the Federal Court of Australia Act 1976. In particular, have a look at Part 5 and Part B, which deals with case management in civil proceedings. Particularly, have a look at sections 37M and 37N. Those two provisions of the Federal Court of Australia Act really come about as a result of the decision in ANU and Aon Insurance. 37M provides an overarching purpose of civil practice to facilitate the just resolution of disputes quickly, inexpensively and efficiently. So that's now the new case management philosophy of the Federal Court, and 37N provides a bit more detail to that. And it imposes obligations on lawyers to do certain things. So we're really now talking about civil procedure, but it does directly relate to ADR practice. Because if you fail to take those things into account, not only may your clients, even if they win, suffer a costs consequence, but it may even come back on you as the practitioner. Do have a look at the Federal Circuit Court Rules 2001 and have a look at the Family Law Act 1975, particularly sections 11A of the Family Law Act, and as we've seen in the past with the certificates, 60I, which says that the court is not permitted to hear an application about a matter involving a child unless a valid certificate confirming a family dispute resolution practitioner has attempted a resolution. All right, I know I'm throwing a lot of information at you, but it will require a little bit of dedicated private research and study. Now, you'll notice, and I guess this is part of my style in teaching, while I'm well aware of the quality of this textbook and other textbooks, I show you the primary sources of the law, because that's going to be the most persuasive if you're in a courtroom. So just remember that not only in this subject, but in all of your law subjects. If you're standing before a judge who asks, what is the authority for that statement that you have made? You are going to be persuasive and the court will hear you if you say, I refer to section such and such, or regulation such and such, or practice direction, or explanatory statement, or explanatory note, or explanatory memorandum. They're not going to pay as much attention to you if you say, yes, but I refer to page 45 of Spencer's textbook. And I must say that with all due respect to Spencer or any other author that you write, you must always go, where possible, to the primary source of the law, not the secondary source of the law. Any questions? You're doing well. You've hung in there. Good on you. All right. Apart from that, at the federal level, have a look at the Administrative Appeals Tribunal Act, 1975. Have a look at sections 3. Section 3.1 defines dispute resolution. In that context, the AAT, and it describes it widely: conferencing, mediation, neutral evaluation, case appraisal, conciliation, or other procedures. Have a look at section 34 Cap A, which provides for the president of the AAT to order mediation even without the party's consent. All right, so that's the federal sphere. At a state level, it'll come as no surprise where I once again refer you back to the UCPR. This time, and look at the Uniform Civil Procedure Rules 1999 in Part 4. It provides for the ADR process. In particular, look at Rules 319, which gives the registrar power to give notice of proposed reference to ADR. 323, which deals with the referral of a dispute to a mediator. 324, period of time for conduct of the mediation. 329 and 331 require the mediator to do certain work. 334 is referral to a court-appointed case appraiser. And then 335 and 343. I know we're just about out of time, but I'll make a little dash here because there's a lot to cover this week. QCAT has certain ADR processes built into it: mediation, conciliation, and hybrid hearings. So, for example, I did a hybrid hearing a couple of weeks ago in relation to a dog destruction matter, a merits review. But where it's a hybrid hearing is that we hear the matter, I make a decision, I write the decision, seal it into an envelope, put that aside, and then say to the parties, all right, now we will conduct a mediation. If we can't resolve it, then I'll unseal the envelope and give the reason. So that's the hybrid hearing. So QCAT has its own ADR processes. The Land Court of Queensland, with the new president, Judge Kingham, has a real emphasis on ADR. So have a look at the practice directions that relate to Land Court. In particular, have a look at practice direction number 1 of 2015 and practice direction number 2 of 2015. I think I wrote a piece on this. I think I've uploaded it. Have a look at that piece. I won't go through it in detail, but it provides some background circumstances and explanation about those practice directions and how they work in the context of Land Court jurisdiction. Also have a look at the Planning and Environment Court, and in particular, practice direction number 2 of 2014. So that's in the P&E Court. Oh, you've done well. All right. Now, you do know how to find practice directions, don't you? It'll be a big yes. Even if you don't, just say yes, because by next week you will definitely know because you're going to go find them for me. Yes. So Mo says, I know how to do it anyway. Easy. All right. So what have we learned from tonight? We've learned that while we think about ADR as being mediation, maybe conciliation, maybe arbitration, there's a whole range of other options that we might call ADR. And there's a whole range of court and tribunal sanctioned or directed ADR processes. And in that regard, look at the NADRAC document that led to substantial changes in about 5 or 6 years ago. Have a look at the legislation, the regulations, the rules, practice directions, because all of that has a bearing on the advice that you need to give to your clients. Okay. Any questions or all good? Shell-shocked? All right, so a lot of reading to do tonight. Don't just read the textbook, go to the primary sources. We might call it quits at that, and I'll stop recording now. Thank you.